We are talking property disclosures as noted. We've got 5 test questions. And then also as another note on the state exam, you're also going to have 5 test questions. And there are a few things here that should help you there, okay? So for our 5 test questions, what are we looking at? The first thing I think you need to know is what is your relationship to property condition when you're working with your clients? And you need to learn about safety and environmental issues. You need to look for things that might be of concern. You need to educate your clients on things that might be of concern. And last but not least, you should never confirm or deny the presence of an environmental or structural issue without it looking from a professional's viewpoint and report. It needs professional testing. So if you see a crack in a foundation, that is not your place to say, don't buy this house, it's going to fall in. That's a major violation. That's a major safety issue. What you should say is that crack could be resulting in some things for this property. It could be water penetration. I don't know. The disclosure doesn't share any of that. But if this is something you would want to move forward with, I would suggest getting a structural engineer's report. That might be something you would say to a buyer. To a seller, you might say, a buyer might want to look at this. Have you ever gotten a structural report before? But you should not confirm or deny without having a professional test it. So know about it, educate about it, look for signs, but rely on a professional to test. Then this could be on the state or national exam. Is who needs to fill out a residential property disclosure. And the key thing I want to highlight here is it is for residential property 1 to 4 units. 1 to 4 units. We don't need it for bare land. We don't need it for 5 or more units. It's 1 to 4. And that's the same on the Iowa code. So you could have that part of it on the state as well. Another exemption I'm going to throw in here. This is someone who does not need to fill out the seller disclosure. That's going to be a power of attorney, someone with written legal authorization to act on behalf of someone else in their real estate transaction. Or the second option is going to be an executor of an estate. So someone's passed away and now their executor is exempt from filling out the disclosure. Both of those rules apply to Iowa law as the other big thing I want you to know for the state and national is the term latent defect, Latent, or in Iowa, we call it a material adverse fact. Material adverse fact. Sounds like I'm in the know, and I am. A material adverse fact, by definition, is going to be anything that would change the value of the property significantly. It would change the structural integrity, or it would pose a health risk, such as an environmental issue. These things the seller has to disclose. In general, these are things that cannot be seen with the naked eye. These are not things that can be discovered through a basic home inspection. So, for example, there's a bunch of hail damage on the siding on the exterior of the home. Does the seller need to disclose that? My answer is no. It's not a structural issue. It's covering the structure, but you can see that with the naked eye. You can see a water stain on the ceiling. with the naked eye. But what I don't know about that stain is it caused by plumbing issues that are behind drywall and in the framing. I can't see that. An inspector can't see that. And unless Superman is your home inspector, we're not going to see things behind drywall or underground, correct? Like sewer systems, water lines, septic tanks. So we've got to rely on the seller to disclose it. My two major exam questions for the exam rather is, let's say there's been water in the basement. Does your seller need to disclose that? Absolutely. That's a material adverse fact. We only know about that water because the seller tells us. Otherwise, we'd have to rely on only showing property when it rained. No, we sell real estate all the time. We don't wait for storms. So that's got to be disclosed. The other layer of it is, let's say your seller says, I don't want to disclose it. What do? You have a duty to disclose that no matter what. The second example that I think could be good for us is, what if you get a call from a listing agent, you're 3 days before closing with your buyer, and they say, hey, just heads up, the well went dry this morning, but don't worry about it because the seller always says it replenishes itself within 48 hours. So it'll have water back in it by closing. Do you need to tell that fact to your buyer? Yeah, absolutely. Yeah, absolutely. Absolutely. I would throw out there just understanding what a home inspector is or does. I might add that we really maybe didn't spend a lot of time on earlier. A home inspector is hired by the buyer to review fire health and safety issues or major repair over $500. Traditionally, it is hired by the buyer. And again, they are limited in their scope of work, meaning they can't see behind drywall or underground your areas that might be covered by building materials. With that being said, I want to make sure you know the difference between a home inspection and an appraisal. Those people are not the same. An appraiser is confirming the quality, condition, size, amenities of the property. They're looking for safety issues in some regards, but they're not pulling out a tester and going to every outlet to make sure it's got electrical current. That's what the home inspector does. So I just want to make sure you know for the exam, those are two different individuals with two different job functions. The buyer hires both of them, one to go through the property, one to verify the value so they can get a loan with the bank. Then I would know the definition stigmatized property. Even though it's not a required disclosure item in the state of Iowa, I would know that it's the definition is something where an event, a traumatic event, has either happened on the property or nearby that would affect its value. And then I would also know Megan's Law. Megan's Law is not a real estate law, but it is a law that requires sex offenders to register with their local authorities. And of these environmental issues, the two I'm really going to review with you and highlight is going to be around radon and lead-based paint. Radon is an odorless, tasteless, colorless, all the things. You cannot detect it with this, or this. It is technically the number 2 cause of lung cancer. And anything above 4.0, the EPA recommends that we mitigate it. For that one, I would know what radon is, that it's a gas that is completely undetectable. And by the way, for the most part, it's pretty easy to test and mitigate for. Let me add that hint. Then lead-based paint, I think we've got an option for multiple test questions that you should be asked. And these are things you need to know also for your career. Number one, any residential property built prior to 1978 needs a lead-based paint disclosure filled out. Now remember, the lead-based paint disclosure is a federal document, so there is no exemptions for executors or power of attorney. It's got to be filled out for anything prior to 1978. Number two, you need to know when it must be signed. And the answer is it's got to be signed prior to the buyer writing an offer or the seller accepting it. It's got to be made available and signed prior to the buyer writing an offer or a seller accepting it. And then the last thing I would want you to know is that the buyer is allowed to have a 10-day window to inspect for radon. That's written in the disclosure. That's not negotiated between buyer and seller. That's actually written into the lead-based paint disclosure that there is a 10-day window. Let me clear that one up. 10-day window to test for lead-based paint. My point was that is not a negotiable time frame between the buyer and seller. That 10-day window is pre-printed into